you who don't know what I'm talking about, hit the page and take a look around. Podcasts are weekly podcasts that we're trying to do a session on specific legal issues and then a session on more general legal issues all related to the States. And we're throwing up a daily blog just to see if we can stay on the internet at the lightning speed that it's going at. So that's been great fun and great excitement, and we also allow offering our clients the opportunity to meet with us and work with us at our local office so that we can accommodate those clients who we've noticed over the years have no interest in coming to downtown Toronto but still want to litigate over the state. The last thing I just want to do by way of introduction is just remind them in terms of those that I've already introduced Craig to my immediate left and Justin Breeze over one more. Susanna Papamonte, who can't be here this morning, is in court, and so is David Smith. The other two partners, and Rodney Hull is not here, but is on his way to college. And we're now blogging and podcasting every day. For those of you who don't know what I'm talking about, hit the page and take a look around. Podcasts are weekly podcasts that we're trying to do a session on specific legal issues and then a session on more general legal issues all related to the States. And we're throwing up a daily blog just to see if we can stay on the internet at the lightning speed that it's going at. So that's been great fun and great excitement, and we also allow offering our clients the opportunity to meet with us and work with us at our local office so that we can accommodate those clients who we've noticed over the years have no interest in coming to downtown Toronto but still want to litigate over the state. The last thing I just want to do by way of introduction is just remind them in terms of those that I've already introduced Craig to my immediate left and Justin Breeze over one more. Susanna Papamonte, who can't be here this morning, is in court, and so is David Smith. The other two partners, and Rodney Hull is not here, but is on his way to college and on his way. We're also, we have Paul Trudell, John Smith, we've got Sean Graham, Bianco Neve, also associates at the firm, and Worker, and Jordan Aiden, and I think if I missed anyone, we can get started. So we're going to start with Craig. He's speaking on his behalf because David's out well trying to earn a living in front of a judge on the first day of David Self, which was removal of trustees revisited.
Good morning, everyone. Obviously, height was not a requirement to join the firm. As Ian mentioned, I'm speaking in place of David Smith today. The paper that he wrote is entitled "Removal of Estate Trustees Revisited." And while I would be happy to answer any questions regarding this paper, if you have a specific question regarding this paper that you'd like to follow up on, I certainly invite you to call David, as he's tied up in court right now, and be more than happy to do so after that. I'm going to address the topic of removal of estate trustees, both in the context of when a certificate is obtained and when a certificate has yet to be obtained, and to provide you with some of my thoughts as to what you might consider in thinking as to whether you actually want to push such an application or a removal, or do so from a strategy perspective. First of all, the appointment of a representative, that is a personal representative, is one of the primary purposes of a will. A testator's right to choose a personal representative will be given, obviously, significant deference by the court, as the court wants to uphold the testator's wishes, as set out in that will. However, there are circumstances in which an estate trustee, even appointed, can be removed. The statutory basis for the removal of an estate trustee can be found in Section 37 of the Estates Act. And Section 37 of the Estates Act is also set out on page 2 of the paper, but quickly. It indicates that the Superior Court of Justice may remove a personal representative upon any ground upon which the court may remove any other trustee and may appoint some other proper person or persons to act in the place of the executor or administrator so removed. So that's your statutory basis. And if we were dealing with a trustee rather than an estate trustee, I would point you in the direction of Section 5 of the Trustee Act, which allows for a trustee's removal. It's pretty clear from the Act that the discretion or the ability to remove by a court is very broad. And frankly, the Act itself doesn't give much help in the way of providing any guiding principles. So in lieu of that, we then, of course, rely on what the case law says. Now, one of the leading cases in this area is, frankly, a case from the 1800s, but nevertheless is the case of Letterstedt and Brewers. And in that case, the court observed that there was very little to guide the court with respect to the issue of the removal of an estate trustee. Rather, the court opined that what they should be looking at are general principles, and that is the duty to ensure that the trust or the estate can be properly, fairly, and correctly administered. In other words, what is in the best welfare of the beneficiaries. And while there have been numerous cases since the Letterstedt case, all of those cases try to apply that very general principle. How do we ensure that there's fair and proper administration of the estate or the trust, in the case of a trustee, while balancing the deference that should be given to the testator's wishes? Now, as stated in Hull and Hall probate practice, although Lord Blackburn's remarks in that case have been repeatedly referred to, the basic principles he enunciated have really not been enlarged or qualified. The subsequent cases simply illustrate the application of those principles to the various set of circumstances. And while I will next refer to the types of circumstances under which an estate trustee could be removed, the fact of the matter is that the court's going to apply that general principle I just talked about, giving deference to the testator's wishes and the direction under the will that may be given under the will, that may have to be interpreted under the will, and to the specific factual circumstances. The typical circumstances where a estate trustee might find him at the wrong end of an application are if there is a bankruptcy on the part of the estate trustee, conviction of a felony, not surprisingly, permanent removal from the jurisdiction. So you may have a situation where an estate trustee is properly living within the jurisdiction but moves, perhaps for work reasons, to a different jurisdiction, and it may very well be that the appropriate decision at that time, maybe not based on wrongdoing, but based on that fact alone, may guide you to actually decide to bring an application or seek a renunciation on the part of the estate trustee. There is also incapacity through illness, age, or inclination, substantial breach of trust, lack of appreciation of duties, inability of trustees to agree, dissension among the beneficiaries themselves, undue delays on the part of the estate trustee, conflict of interest, and inappropriate or improper behavior. And so those are sort of the earmarks. If you can identify those issues, then one might consider bringing an estate trustee removal application. Procedurally speaking, it's done by way of an application pursuant to Rule 1405, subsection 3. And that's brought before the Ontario Superior Court of Justice. Now, once you've brought your application, you're then in a position to decide what other relief you may wish to piggyback on top of your application. It may very well be that if it's a consideration of inappropriate behavior, negligence on the part of the estate trustee, that you decide in turn that you should have a passing of accounts. So you may want to marry up relief with respect to a passing of accounts and the removal of the estate trustee. Quite frankly, if you're bringing an application to remove an estate trustee, you ought to be considering who should be replacing that estate trustee if there's not a situation of co-trustees. And to that, you may also have to look to the will, because the will itself may provide that even though two estate trustees have been appointed, and there's an allegation of wrongdoing on one, you may need to have at least two estate trustees. So you may not be able to default to just one of the other co-trustees in that kind of circumstance. So again, the will in itself may dictate how you decide to proceed. Now, David's paper also talks specifically about removal in the context of conflicts of interest. And David does a very nice job of setting out a number of different cases that one might look to deal with various conflicts of interest. I'm going to invite you to read David's paper on that rather than going through each of his cases. But I will just note for you the types of instances that David refers to, which may grab your curiosity. David speaks to circumstances such as where the estate has a claim against the executor to recover assets which may form part of the estate. For example, a promissory note. Perhaps the executor or the estate trustee had a loan obligation to the deceased prior to the date of death and is reneging on the payment of that note. Well, that's obviously a situation where there's a conflict of interest. It may be just a simple failure to pay a debt. There could be a lack of unanimity amongst the executors themselves as to the issuing of a lawsuit, and that may lead one to a particular conflict of interest if the interest can be tied in some way to the reasoning as to refusing to agree to initiate the action. Where the executor, him or herself, has an actual claim against the estate. It may actually be the reverse of what I just mentioned. It may very well be that the deceased had a debt owing to the executor, a debt which may have been not surprisingly founded on a handshake as opposed to a written document. That in and of itself may represent a situation that should be queried. Were the executor or estate trustee and the deceased involved in business dealings? It's not uncommon these days for business partners to have a privately owned company, and there could be a shareholder dispute. Maybe one was a majority shareholder, maybe a minority shareholder, and they want to assert their rights. And asserting their rights may be doing so in the context of a state administration. So that is also something to keep your eye on. Also, spouses who make elections under the Family Law Act would place themselves in a conflict of interest. Dependents who make dependent support claims may be placing themselves in a conflict of interest by making that claim. Although there are cases, and there could be good argument to say that that estate trustee may not need to be removed on a permanent basis, but just an interim basis to deal with the support claim itself. And then once the support claim is dealt with, and there's no issue with respect to the balance of the administration of the estate, that estate trustee can once again continue on with the administration. And the last circumstance I believe Dave deals with is when a named executor may have been an accountant or in the business of reviewing or doing an audit on the deceased books or personal finances, whether that be simply on a personal basis or perhaps even in the form of a company that the deceased owned. That would be placing that person in, frankly, a conflict of duties. What their duty was as a person in their role as an auditor, and then their duty in their capacity as a state trustee. So those are some situations that David takes a look at, and I invite you to review the paper on to see the cases that David refers to. The other instance that I mentioned that I'd like to take a look at is what happens when the estate trustee has not yet assumed the position of estate trustee. That is, that there's no formal office from which to remove the estate trustee. In other words, there hasn't been a certificate of appointment with or without a will obtained or issued by the court. One way of dealing with that is by what's commonly referred to as passing over. And passing over is a mechanism whereby the estate trustee appointed by a will is formally skipped. So not actually removed, but formally skipped, such that another estate trustee can assume the position of the executor in his or her place. And the order that you would want to obtain is akin to a removal order in the context of providing for the reason, that is that the person cannot act. Another estate trustee would be named, and also they would have to be given the authority to seek and apply for the certificate of appointment. Again, passing over should be contrasted with the formal removal of an estate trustee, because in the estate trustee context, again, that step is taken once the estate trustee or executor has been appointed and has obtained the certificate of appointment. Also, passing over should be contrasted with renunciation, whether it is deemed or otherwise. Where an estate trustee renounces, that is, just simply decides that they don't want to accept the appointment, then you find yourself in a situation where you look to the will to see if there's others that have been named and can be properly appointed, or if not, whether somebody else has to simply be put up as the appointee and then be decided upon by the court. In a deemed situation, that arises when somebody has frankly gone to the court further to an order for assistance and formally requests or requires, given that it's an order, that the potential appointee accept or refuse the appointment. And by taking this step, which can be done over the counter in pursuant to Rule 7415, you can basically cut short the need to do a formal application for removal or for passing over. So that should also be looked to at first instance. Perhaps it's just a matter of delay. Perhaps the proposed executor needs some nudging or a swift kick to take on the role. And by formally getting this order for assistance, you're putting them to the test of making that decision. If they make the decision, and frankly they make the decision you want them to make, then you don't have to bring your application to remove them either for passing over for other reasons. Now, the circumstances under which passing over are typically sought are again not that surprising. When there's a minor that has been named and may simply just not have come to age of majority, a person criminally responsible for the person's death. I mean, I suspect that would be a tough argument to uphold that appointment. A bankrupt, a corporation in liquidation cannot act, and a convict serving a lengthy prison sentence may be passed over. An incapable person also cannot act. So those are relatively straightforward and probably obvious situations where the courts have recognized that passing over can occur. And I would just point you in the direction of a case that is cited by David. It's called Stadelmeyer and Hoffman, or otherwise known as Rebecker, and also the Carmichael case that speak to passing over. So those might be guides for you as well. And then lastly, I thought that I would mention that having given consideration to what I've just said and to David's comments in his paper, that you actually consider, again, the relief that you actually need to seek. I've already mentioned that you might want to contemplate a passing of accounts. And frankly, if an institution is going to be appointed in some sort of capacity, whether on an interim or permanent basis, they may actually demand that there be a passing of accounts so they know what the starting numbers are and the starting line with respect to the administration. Further to that, I usually put my mind to, at this point in time, what is it that I need, that I can get the assistance of the court, having the sympathetic ear of the court at this point in time, to help me with the further administration. It may very well be that I want to add parties to the proceeding if I've got issues within the estate as to disputes. I may actually go for an order requiring financial institutions to provide documentation. What happens if there's an allegation of negligence on the part of the estate trustee and you don't believe that you're getting all the documents from the estate trustee with respect to financial records and statements of account? Why wait for the actual dispute and examination of the process? Ask the court up front if the court will give you that assistance so you don't have to do it later on, and you can contain your costs and your materials by looking to those kinds of situations at this point in time. And then I guess lastly, I always consider whether I actually have to bring the application. Or if I bring the application, do I actually need the relief? And by that I mean, if I freeze the assets, if I can get an order from the court to freeze the assets on an interim or permanent basis, do I really need to actually formally go through and perhaps get into a very contested and disputed removal application? Perhaps the parties at the end of the day, whether I bring the application or not, will simply agree to freeze the assets, allowing for certain directions by the court to administer the assets of the estate and pay certain liabilities, and then deal with the dispute, and then come back to the removal if it's still an issue at the end of the day. A common example of this is there might be a house or a commercial property that's in dispute. That may be the only asset in dispute, and a court could freeze the ability to encumber that, to transfer it, to sell it, to dispose of it, and also allow the parties out of the accounts to pay the utilities and any mortgage payments that may have to be made. You may be able to deal with with the actual asset by simply asking the court for freezing of the asset. Those are my comments, and I thank Dave for writing the paper.
That's to significantly adjust the mic. Thank you very much, Craig, and thanks for stepping in for Dave. Our next speaker is Justin DeVries. He's going to talk about standing in the shoes of an estate trustee and getting paid.
Good morning and welcome. Just a quick sidebar, and that's about my tie, which you will see is very orange. It's not meant just to wake you up. As some of you may know, DeVries is a Dutch name, and of course, for those of you following the World Cup of Soccer, Holland is playing today against Argentina. And Bianca of our office, she's right beside me. We have an ongoing battle because she unfortunately supports the other team today, which is Argentina. So if you see her, you should probably offer condolences this morning. Turning to the topic now, I think we all know that estate planning has certainly become more complex. People are getting wealthier, if nothing else. Homes now form a large part of what would have been a modest estate 10 years ago, can well be over $500,000 or more. And we have all read, probably ad nauseum, about the transfer of wealth that is coming, both between the generation that lived between the two wars or were born between the two wars, and of course, the baby boomers are quickly approaching retirement, and that will bring its own basket of interesting issues, no doubt. I think it's true that Canadians are also busier. We're looking after elderly parents, looking after adult children, more and more we see. So I think what we're finding is that people who are asked to be estate trustees are looking for help more and more. And lawyers, of course, have traditionally provided that advice, at least legal advice, to estate trustees. But I think we are now seeing more and more where lawyers are being asked to perform duties that are normally reserved to the estate trustee. And it's not only lawyers, I think agents and individuals and institutions are being asked more and more to take on those duties that normally an estate trustee would do. So the question of my paper and the topic this morning is, how do you ensure you get paid? Courts, of course, are quick to criticize people who take too much money from an estate, but the reality is that often these services need to be performed and they can be expensive. The duties of an estate trustee are well known, and I won't go through them. But one of the things that all of us should keep in mind is that, of course, an estate trustee cannot delegate the responsibility to make a decision. So that is something that really rests with the estate trustee. They can seek advice, they can seek information, but in the end they can't delegate that to a third party. Often what has been delegated to a lawyer or a third party is really administrative or secretarial functions. That may be a little light in terms of the description, but there can be some significant duties that go along with that. There has been some direction provided by the court recently, and it was by Mr. Justice Cullity in the Bott versus McCauley decision. It was an August 2005 decision, so it's coming up to a year old. It was not appealed, but it's not been widely considered either, so we'll see how it stands the test of time. But of course, Mr. Justice Cullity, as you know, is well respected in the area, and for good reason. In the end, what one needs to take away from that case, and I think the direction the court is trying to provide, is that a solicitor who performs the services normally reserved for an estate trustee really can't claim that they are getting estate compensation, that they are getting estate trustee compensation or executor compensation. Moreover, a lawyer cannot argue that you can really, that the estate or the estate trustee or beneficiaries can really challenge those fees only on a passing. Mr. Justice Cullity was clear to say that an assessment is really the way that that process needs to take place in terms of a lawyer, and I think by analogy, in terms of an individual, institutions are really dealing with a commercial contract. That is a commercial contract between the estate trustee and whoever the third party is who's performing some of those functions. Even if there is an agreement in place, it does not necessarily, of course, bind the estate or beneficiaries. It's really, as I said, with the estate trustees. Even where there's a special fee that's agreed to or a percentage to be paid to an estate, to a lawyer, for example, helping out an estate trustee, it can still be challenged. So there's nothing preventing the courts from exercising its jurisdiction to look at that relationship. The court can, of course, determine if such a fee is unconscionable during a solicitor's assessment, for example. And the court can also determine, as was the case in the Bott action, that the lawyer should be paid really on a quantum merit basis. That's a fancy way of just saying value for services. So I render so many services to you, and you should be paid accordingly. And I think, again, by analogy, though the case doesn't deal with it, it's also true for an agent or an institution or a third party. You really have a separate agreement with the estate trustee and not with the estate per se, because as we all know, the estate is not a juridical person. It can't retain anybody. It can't assume liabilities. It's really with the estate trustee that you're dealing with. And that third party or agent would very much have a cause of action against the estate trustee. And that cause of action would have to be dealt with, in my view, separately than on a passive. Sometimes the court will look at it, we'll talk about that a little bit, but if you're really looking to sue for your services and you're not a lawyer, you can do that by way of starting an action against the estate trustee. Now, a lawyer, of course, can go by way of assessment to have their account paid, or they can also start a separate action. The Solicitors Act is probably the more common way to go, and that's by bringing an assessment. Now, in terms of the Bott case, just to bring you up on some of the facts, which are always interesting, it really was a dispute concerning the fees charged by Mr. McCauley for both legal services and for services that he performed on behalf of the estate trustee. He was retained by the estate solicitor, and he rendered two accounts, one for legal services of approximately, I think it was $74,000, or $7,400 rather, and one for approximately $34,000, which related to services that he performed on behalf of the estate trustee. Now, Elma Bott died in 2003, and her son Gerald was appointed estate trustee with the will in August 2003. And the will left the entirety of the estate to Gerald, the son, and his sister in equal shares, and the value of the estate was approximately $650,000. Bott, in an affidavit that he put before the court, claimed that he had little experience being an estate trustee, which obviously is not uncommon. Most people, most individuals, unless they're a lawyer perhaps, or an institution, would not have the experience to do that. And so Mr. Bott decided to retain a solicitor in order to help him administer the estate. As I said, two accounts were rendered. The first account for legal services was not really an issue. So what we're dealing with is the second account that was rendered for $34,000 and change on behalf of Mr. McCauley for services rendered to the estate trustee. And that represented approximately 5% of the value of the estate. So you can see how things are being set up in terms of the fact. The one thing that Mr. McCauley or the solicitor did was he pre-took the $34,000, which ultimately Mr. Justice Cawley reversed, and I'll talk about that in a minute. The solicitor, Mr. McCauley, took the position that the court had no jurisdiction to order an assessment, that it was really dealing with a passing of accounts, that this issue of his fees for services should be considered. He was essentially arguing, I think, that it's really state compensation that we're dealing with, and so we should deal with it on a passing, and the court does not have the jurisdiction to order an assessment of that. However, Mr. Justice Cullity disagreed and took the position that he did have the jurisdiction to order an assessment, and he did. And the case goes to some length to discuss that jurisdiction. One thing to note as well is that you have to be careful when you're describing the type of work you're performing, especially if you're a solicitor. So are you doing legal work, or are you doing the duties of an estate trustee? Because at one point, as Mr. Justice Cullity pointed out, some conveyancing work was characterized as duties of the estate trustee. Now, without offering a criticism one way or the other, because the courts often operate in a very dry vacuum when they're considering these things, Mr. Justice Cullity felt that that should really be legal fees and not characterized as duties of an estate trustee. So again, something to keep in mind going forward. If you're in that position, be very careful, especially if you're a solicitor, how you characterize your work. There was also some confusion about whether there were one or two retainers that Mr. Bott signed. Not surprisingly, lawyers will often want things in writing. And two retainers were put in front of Mr. Bott. One was dealing with legal services, and one was dealing with estate trustee services. Now, Mr. Bott opined in an affidavit that he didn't know he was signing two. And in fact, he really didn't sign two, he said, which Mr. Justice Cullity accepted. In essence, Mr. Justice Cullity had to accept that because Mr. McCauley, the solicitor, really didn't put in any evidence to say that that was not the case. So the court, by default, really accepted what Mr. Bott's position was, and that was, I didn't know I was signing two. So the point there is clarity. If you are going to take work from an estate trustee to do some of those duties, then you should make sure that the retainer is very clear and the client understands without a doubt what it is that they're signing and what it is they can delegate and when you're going to charge for legal services and when you're going to charge for estate trustee services. So keeping accurate accounts, obviously, is always a wise move. Often lawyers, unfortunately, because docketing is our bane, do very quick notes as to what we're doing. It makes more sense if you're in that situation to have a very clear record of the work you performed as a lawyer as well as a state trustee, so you can really demonstrate to the court and the client, if need be, that there is a difference. Now, as Mr. Justice Cullity pointed out, it was really a relationship between the estate trustee, Mr. Bott, and the solicitor, Mr. McCauley. The relationship is not between the estate and a solicitor or a third party or agent. It's the estate trustee who retains a solicitor, either to do legal services or other duties, or retains a third party to perform the services of an estate trustee. It's, as a result, the estate trustee who is liable to the person who they've retained. Now, of course, an estate trustee can ask for an indemnity and reimbursement from the court, and that's the normal course, and it's usually not an issue. But nevertheless, from a legal perspective and on first blush, it is always the estate trustee who is liable. And I think that's very much true where you have a third party or an agent, where you really have a commercial contract with a third party to perform some of these services. That's really a commercial case that has to be dealt with, not on a passing, but it would be dealt with on a normal course action, I would argue. Now, of course, the court has the ability during a passing to look at the reasonableness of what it is the estate trustee has done in terms of incurring expenses. So, of course, the court can look at a bill that has been rendered by a solicitor and say, frankly, I don't think that's reasonable, and it's going to be reduced accordingly. It's not necessarily the same as an assessment. And that's an important distinction. The court can say, I think you've charged too much, I'm going to reduce that. And that's really for the benefit of the beneficiaries. The estate trustee still has an ability to assess the accounts of the lawyer to say, you overcharged me, be it for legal services or estate trustee duties. And conversely, the lawyer or the third party can go after the estate trustee because hopefully the retainer is clear and everybody knows what they're paying for and there's no confusion about, I didn't know I was retaining you for that. I thought my compensation or your legal services were limited to what I got awarded from the estate. Now, the difficulty as well is when the court looks at that reasonableness, they can also, for example, decide whether or not an estate trustee should get an indemnity directly from the estate. So you're really now moving from just a reasonableness of argument to, well, are we going to indemnify the estate trustee? And in that sense, the court is really beginning to move in towards an assessment. And the court also has the discretion, in my view, to actually conduct an assessment during a passing of accounts, separate process. Now, the danger here is, and for the lawyers in the room will know, is what we call natural justice. All of a sudden, you're looking at a solicitor's account carefully, and the solicitor may not have an ability to give evidence about his account, which would happen on an assessment. There's no right to cross-examine the client to say, did you not give me these instructions? Did you not give me this letter instructing me to do X? So the court, in my submission, would have to be very careful when it starts to conduct an assessment within a passing of accounts. And I think the usual course is that the court really just looks at the reasonableness and will deal with the issue of accounts on a separate assessment or in a commercial dispute if it's a third party. Now, it's important to note that the rights of the estate trustee and the solicitor who performs services beyond those of a legal services are not really affected by the reasonableness. As I said, that process is separate. The court can decide on the reasonableness of the expense incurred by the estate trustee, and yet there can still be an assessment. Mr. Justice Cullity was clear, and another important point to recognize is that there was nothing preventing an estate trustee from getting this assistance of a solicitor or a third party to help with the duties of an estate trustee. So that's not really the issue. We have the reservation that you can't delegate responsibility for decisions, but in today's world there's nothing to prevent an estate trustee from going out and getting help. But it has to be clear, there has to be an understanding of what's going on, and the court retains a jurisdiction over lawyers through an assessment or through third parties who are not lawyers in a normal commercial dispute. And again, it's always the estate trustee who's personally liable for that, at least at first blush, and that's where the action is going to lie. Now, of course, if an estate trustee delegates responsibility for performing services, then of course compensation may likely be reduced. It depends on the complexity of the state. It may be you can argue that it was necessary. It saved the money for the estate. You know, a typical fact scenario. As lawyers like to say, if the law isn't on your side, then argue the facts. So it very much depends on really what the situation is. But generally, you're not going to be double compensated. You're not going to, delegate your duties and then get paid for that. Mr. Justice Cullity said as well that absent any special agreement, a lawyer would likely get paid on a quantum merit basis. So value for services, which is a good reason to keep good dockets for the lawyers in the room to know exactly what's done. And it's also true for a third party. They should have a record of things that they have done so they can demonstrate to the court that they're not just pulling a fee out of the air. Again, if you have it up front, you probably won't have any problems. On an assessment, of course, the court will look at the reasonableness of the fee, the labor involved, complexity, the result, all the usual factors that a court will bring to bear. There can, of course, be a special rate. There can be a percentage of a value that is agreed to in terms of paying a solicitor for work performed or a third party, but the court will look at that. The court can find, and often will, that a special fee is unconscionable. It's unconscionable, it's not enforceable. So again, there's always that patina of overriding jurisdiction that the court will bring to these kind of situations. Now, just to finish off, in the Vaught case, Mr. Justice Cullity held that there was no agreement between the solicitor, Mr. McCauley, and the estate trustee in respect of a special fee. He said he should be paid on a quantum merit basis, and a judge can often instruct, which Mr. Justice Cullity did, an assessment officer, who's the one who performs the assessment, give them directions as to what they should do, that is the assessment officer, in assessing the account. So he said to the assessment officer, Mr. Justice Cullity did, these are the directions you need to follow. He also said that when you do the assessment, don't look at what was awarded to Mr. Vaught as estate trustee. So that's not a factor, he said, in considering how much Mr. McCauley is claiming against the estate. So in the end, the solicitor was required to deposit the money back in an interest-bearing account and also to pay interest on that during the completion of the assessment. And I am told that in the end, settlement was reached, and so it never proceeded to an assessment. That's my presentation. Thank you for listening.
Thank you very much, Justin. I'm going to talk about joint accounts, and I was intrigued and pleased before this seminar to get an email from Vicki Phillips, who's now listening to the former city of Etobicoke and now swallowed up by Toronto, and her office is online today. to get an email with some questions about the topic and to tie into my zealot desire to blog and podcast. I think it's an interesting concept. It's a great idea. If you get these topics and you see it and you're interested in coming and you think there's a little angle or something you want to see addressed, Vicki just gave me some points, and I'm going to try to dovetail some of those comments, those questions right into my comments today. And they were excellent questions, but feel free to interactively involve us in this. Certainly, if you know you're going to be able to either listen in or come down. Now, the joint accounts issue, this is an issue that, in some ways, I'm blessed because I had the opportunity to mediate a case all day yesterday until 10:30 last night on the joint account. And so the litigation is going to be endless and fraught with disasters in its own way. But it struggles me, and I started thinking about my presentation, and this is such a simple concept. But we've got, in my paper, I deal with the Lyle estate and Justice Cullity, and he steps in and, of course, writes many pages of interesting dialogue on the issue. And then we just recently heard that the Supreme Court of Canada has granted leave to appeal on the two Ontario Court of Appeal decisions on joint accounts, which I'm going to talk about today. So I guess I have to admit that this concept is probably more complicated than I'm letting it take the simple idea and letting it sort of sit there. So I thought about, well, why is it so difficult? Or why would anybody at Supreme Court of Canada be interested in an estate case, and second of all, interested in a joint account case? And I think two things. One is that it is such a core part of financial estate planning now that I think the court wants to step in and give some common direction, presumably, and I guess it has national interest, although I've been lucky enough to be involved with seeking leave to appeal on some other cases in the Supreme Court of Canada, which I thought were way more important, but didn't get leave. But the overlay of the legal concepts, I think, is what needs to be considered and what I want to do today. Because, I mean, the bottom line is our clients won't get off the fence. Is it a gift? They won't communicate it's a gift. We maybe aren't as good at prodding our clients and pushing them back and saying, look, wait a minute, just what do you want to accomplish here? And it isn't just about probate avoidance. And because of that, what we do is we allow really smart people like Justice Cullity, or just as smart people in the Supreme Court of Canada, play with these legal concepts, and with the goal of trying to come to the ultimate intention of the joint account creators. And typically in our area anyway, the joint account creator, one of them is typically dead. So we're sitting here trying to create a story and develop what intention is in the creation of the joint account. So I just for fun sat down and wrote just some point forms in terms of the legal concept list that apply to joint accounts. And I came up with 12 ideas, just really without trying. I mean, there's questions of gift and the law around gifting. There's questions of onus, and that has about 3 or 4 subcategories. There's presumptions, there's 4 presumptions. Presumption of undue influence, presumption of resulting trust that comes out of the case law, presumption of resulting trust that comes out of the statute, presumption of advancement that comes out of the case law. Then we've got constructive trust issues. We've got secret trust issues. We've got mental capacity issues. We've got power of attorney issues and use and abuse and the like, and the advent of internet banking, where we can just, you lose a password and you may lose control over your money to your attorney forever. There's case law review and analysis that I'm going to talk a bit about today, just to see where I think things are sort of going along. And then, of course, I couldn't resist what seems to be the reason why all of these joint accounts are ultimately set up, and that is we've got to avoid that dominating and overbearing 1.25% probate tax that we're going to pay on debt. So I wanted to step back. I've got 12 at least without trying issues that touch on a joint account. I'm pretty sure, and this is much at fault of this, but I think I'm pretty sure I am not saying to my clients as clearly as I should, well, you're going to set up this joint account, and just by the way, there's at least 12 legal issues that are going to surround that, and you may want to be careful because you've got sharks like Hull and other guys in that firm that just want to chew that issue up and maybe even refer to Supreme Court of Canada decisions on it. So maybe this probate fee avoidance may not be the best tack. But, okay, fine, they still want to open and create a joint account. So I say, okay, God bless you, let's go. And so I'm not sure we're saying to our clients, is it a gift? Is it a trust? How do you want it dealt with? Most of them are going to say, look, I just want Betty to be able to get access to my money so that she can pay my bills, I trust her. Well, is that something else? Is that a trust? Is that a... I don't think so. Is it a gift? I'm not sure. And the truth is, the banks never ask this question, and I don't think they should have to ask this question. I mean, at some level, maybe people want to stretch that argument one step further, but I'm not sure that that's the answer. I think the answer, and what I found in my practice, is just to say, okay, no problem, you want to do it, but I've identified 12 legal issues that I'm going to have some fun with in many different courts. And just as I was coming over here today, I was flipping through the most recent issue of Willpower, and sure enough, there's a case there from Nova Scotia, just on this issue, and it's one of these things that the case law is just pouring through the system. All right, so let me spend a few minutes on some of these famous 12 issues. I won't get through them all in great detail, but I think that at least if we can issue identify, first of all, there's at least 12, client, understand that. Second of all, what's a gift? And I hearken back to Justice Greer's comment, it's an opening comment in my paper. She defines a gift as follows. A gift is not a kiss in the dark. Unlike the memory of a kiss, which fades in time, the giving of a gift has lasting consequences. I thought that was kind of a good starting point, and kind of one of these non-legal definitions that I can actually understand. So what is an inter vivos gift? Well, I think the key the court seemed to be saying was just classify it. Classify what you're doing here. Is it an inter vivos gift? Is it a testamentary gift? And then once you start to determine the nature of the gift, has the gift been perfected? Have you actually given it away? And the giving away is what is the underpinning problem with the joint accounts, because you don't necessarily know that answer, and we're not asking that question hard enough. I'm not sure we always want the answer either, because at the end of the day, it really 9 out of 10 times comes down to the fact that I trust Betty, and I don't really want to answer that question because it makes my head spin from a client standpoint. So once we classify it, the courts say this. They say you need a present passing of interest to make a gift. It has to be irrevocable, and it must comply with formalities. You have to justify the transfer. And again, in the joint account context, it's really hard to see the justification process unless you properly document it and you can do some of the things that we're probably going to talk about that the courts have seemed to see helps. So the test of an inter vivos gift is that you need to have done these kinds of things. So what is the dilemma? Well, the joint account dilemma is primarily one that we start off and say, joint account with right of survivorship. Is it just a joint account? Is it not some confusing documentation attached to it because it's tied into an insurance-related product? The key that, and Justice Cullity says this in the Yao decision, and the court has consistently since that decision said, is that you've got to look at the banking or the relevant documents that create it. Just like when we analyze a will in the context of a will problem or a trust in the context of a trust problem. These documents are a starting point. But the interesting thing that Cullity said in Yao, and I think it certainly was what the Supreme Court of Canada will do, Cullity said, but don't get too excited about the banking document. That's just one factor to a court, and it's not, I mean, you didn't come right out and say this, but it seems to me the courts are saying, it's not the overwhelming factor. The banking documents are a factor that has to be looked at. You have to make sure you considered it, but whether or not it is the be-all and end-all, Cullity said it's a factor, and it's not like the analysis that you undertake when you look at a will, because the will is a document that has the legal consequences that have been tested for 600 years, and the courts embrace the validity of it and the process. They're not as excited about joint account documents that a bank has created and that not too many people will necessarily put a lot of thought to when they sign it. So I think the other legal concept that I wanted to sort of think through was the question of onus. And the question of onus is important because in the joint account, someone is going to say it's all to the estate, and someone's going to say it's all to me, mom gave it all to me, and oh no, and when mom died, it was all passed to the estate. It's a pretty easy argument there. Is it a gift? We talked about that. The onus is on the recipient of the gift. And my paper deals with the case of Niles versus Lake. It's a Supreme Court of Canada decision. If the Supreme Court of Canada doesn't say it again, then Niles versus Lake is the law. Things have really changed. And it's a 1945 decision, and it basically says a person who transfers money into a joint account When they do that, there's a presumption of resulting trust in favor of the transferor. So whose money is it? It's the person who put the money in. So taking that classic starting point, then we can obviously look at overlays like the banking document with rights of survivorship, those kinds of factors. But the onus is on the recipient, and it's very different than in a will situation. When you're a gift recipient under a will, you have to propound the will. You get a will, and it's the last will of the deceased, and someone challenges it, you're the propounder, you're the plaintiff. Well, if you get a gift, you have to prove that I properly bona fide received that gift without undue influence, without pressure, that it was a legitimate gifting process. So the onus is very different. And again, a joint account is an inter vivos activity. I wouldn't even call it, I don't think you can go any more specific than that. It's an activity that you do during your lifetime. All right, so now that I've started to get the basics, I've got onus, I've got banking documents that are helpful but not crucial. Then I've looked at my list of 12, and I talk about this concept of the principle of advancement. And this presumption of advancement from a statutory standpoint is set out in the family law. Section 14 says, property held jointly between spouses as joint tenants, in absence of evidence to the contrary, is presumed to be held as joint tenants. So money on deposit in the name of both spouses is deemed to be in the name of both spouses as joint tenants. So there's a family law context to this earlier talk about Niles versus Lake, that this idea that if I put $100 in the bank and it's in a joint account, Niles versus Lake says that was my money, and it's presumed to be on resulting trust that I can take that back. But that's not the case statutorily under a family law scenario. So that's one of these things I think, okay, I remind myself, okay, there's an exception. But let's come back to the rest of the world where it's not so clearly defined. The presumption of advancement in the case law, in a non-husband and wife outside of Section 14 world, the presumption is the transfer intended to make a gift to a child, because there's this presumption, this is a gift between parent and child, there's a presumption that there's a special relationship between these two individuals, which presumes that the gift was intended. So, again, it's not that difficult for me to understand that if I give my son $10, whom I love and adore, I gave it to him for the purpose of him to enjoy it, and it's been advanced to him, and I think I can rely on these presumptions of advancement and rely on the fact that I have gifted that to my son because of that special relationship. So the Yao decision, as I say, was the starting point, and I'm not going to go through it in any great detail. When it first came out, we actually enjoyed going through that case, and I had the pleasure of doing a short comment on that decision at a breakfast series a few years ago. But what that decision did was it really set the stage for where we're at now. What we have now is the British Columbia Court of Appeal started this sort of wave here, in the Cook estate. And in that case, there's a joint account with one daughter, and the estate was divided equally between 6 children. The great fact was that the joint account had more money in it than the whole estate. So, lo and behold, the one daughter who got the joint account, on the survivorship, her banking documents were clear, had to suffer through a lengthy trial with her siblings. And the court held at trial that the inter vivos gift was a valid inter vivos gift to the daughter. So the gift, it was truly a joint account, and it truly passed to the daughter by right of survivorship. Well, why did that happen? Why it happened were the facts. It was 8 years ago that the joint account was set up before the mother died. There was no question as to capacity at the time. I'm going through my list of 12. The daughter didn't use the account, big deal. The court didn't get excited about that, but she got the checks to be able to use it, and she got monthly statements. And the court pored over the facts and came to the conclusion that those were important starting points to developing whether or not the account should pass to the daughter by joint right of survivorship. Then the court said, but that's not good enough because we're dealing with the dead person here. So we need some corroborative evidence. I need some more meat in the bone here. Just because it's a loving, long-term relationship, that wasn't enough for the court. So the court said, what we also like is the corroborative evidence in this case is that 6 years ago, the deceased mother transferred real property to the daughter in joint tenancy as well. And that property was eventually sold during their collective lifetimes. And that money went into the joint account. So the court was looking around for some, they really liked the daughter. They looked around for some corroborative evidence. They found the corroborative evidence. And the solicitor's evidence as well was consistent with this whole special treatment. So the court said, daughter, you get to keep the money. So I think the lessons there were, in large part, in that case, they had an excellent lawyer who documented it. There was corroborative evidence that was documented again by this. It just happened that the court really liked this joint tenancy property transfer as their corroborative evidence. And you had a good story. So in our cases, if you have a good story, which is, well, or a bad story, quite frankly, as you know, we don't care which side we're on. Let's presume they're good stories because they're going to be easier. You have a good story. You have a beautiful son or daughter who's done everything, had this account running, always got the statements, never touched the money because it was mom's money because she needed to be looked after with that money, but when she died and there was still lots left because we didn't really look after her very well, there's a couple $100,000 that our daughter wants to close her hand on the money. What the court's saying is that it's sort of tell a good story, so we can do that, and lots of people can do that, parade with elderly people for a few years and do the hand-holding to the doctor. But get some corroborative evidence, maybe something a little more than just they really like each other, and maybe get some other evidence of gifting so we can ask them. One of the questions that Vicki Phillips asked is what kind of evidence we should be creating. Well, in that case, in the Cook estate, the Court of Appeal latched on to a lawyer who had documented this intention of treating the daughter differently. And he documented it by the transfer, he documented it by the will, and his actual notes demonstrated this special relationship. So those were things, those are hooks that the court grabbed on. So the last two cases that are of some consequence, and the ones that are going up to the big house, are Pecori and the Saylor decision. And I'll just talk about Pecori quickly, because that's the Court of Appeal decision. In that case, the facts were that there's joint assets with the daughter. Now, again, coincidentally, about 80% of the value of the testator's estate was in this joint account. The testator worried about deed disposition, was very fixated about deed disposition. Someone had told him that that's important. So the testator writes to financial institutions and says that he says in a note to them, I retain 100% ownership and I'm only transferring this in joint with my daughter for probate purposes. So I'm guessing that the lawyer didn't draft that letter. But in the case, what happened was the facts get a little spicy because the testator changed his will, gave the estate to his daughter and to her husband. And the joint account was with the daughter and the husband. Now, the husband turned out that he had severe physical disabilities. He was actually quadriplegic. The daughter was the primary caregiver. 2 years after the date of death of the testator, the daughter and the husband divorced. And the husband says that he should get 50% of that joint account in the family law proceedings. Now, it was interesting in this case because the siblings didn't fight. They didn't get involved. They knew the daughter was, I guess, dutiful. But the joint account was held to be the daughter's alone. And what the court did was go through this whole analysis of looking at the financial documents, the timing of the gifting. But then Justice Lang, and really I think is what I hope the Court of the Supreme Court of Canada will embrace, is that she said this, and it really makes sense in terms of simplifying the process, because that ultimately, as I started at the beginning, it's got to be a simple concept. The court said, we want to look at what the intention of the deceased was. And we're going to look at the facts, and we're going to look at the circumstances, and we're going to look for corroborative evidence, and we're going to look for all of these things. Now, guys like, Professor Waters and some of us who like to play around in this world of the state's concepts, if you guys want to play this heady academic analysis of presumptions and bonuses and all of that, it's not really going to fly anymore. It's 2006, and we're not all that excited about it. We're going to find the intention out first by looking at around the circumstances. We'll come back to your concepts of presumptions and your concept of advancement and all of those sorts of things, only if the facts are not sufficient to clearly establish the testator's intention. So, and the Saylor decision, which is the other decision that's going up to the big house, followed the same approach. So the court kind of said, put aside the 20 pages that we studied in law school to get through the exam on these concepts. Let me find the facts. And I think although I think it's the right decision, it works in its own way, but I think it's a good lesson to us as solicitors that we've got to say to our clients, and I'm saying it now every time I can, is that just tell me what you want to do with this money. What are you trying to accomplish? Because if you don't, and if I don't document it in some meaningful way, and I don't have sufficient property evidence, that you're going to give this file to a great litigator and a ton of file with a case about facts. Because the law is they're distancing themselves from the presumptions. You're not going to be able to go into the court with any certainty. How the facts are going to fall, it's obviously a roll of the dice. So it seems to me that we have to really stay vigilant and focused on how we want to set up these joint accounts and stop letting our clients just sort of say, I'm doing it because I'm avoiding probate fees and it's all a great idea. So those are my comments on the joint accounts. I hope, Vicki, I've covered your questions. One question she asked at the end is if it's not a gift, but it's held for the benefit of the estate, clearly the facts show that, are probate fees payable on that joint account? And I will say in a fairly controversial answer is that my view is yes, you have to pay probate fees. If they're clearly in estate assets, it's been identified that, they're going to be treated like that, their probate fee attachment will come to that. Notwithstanding the fact it's in a joint account and maybe the government attorney will go with that. All right, so I hope that's been helpful. Thank you all for coming to this beautiful morning, and have a great summer. We look forward to seeing you in the fall.